The parties are subjected to two separate orders. Defendant has been subjected to false allegations on September 5th, 2015, and was found not guilty on September 17th, 2015. This incident came 1 week after parties attended a child support conference where plaintiff was caught in a lie about second job she was hiding from support officers, which led to support officer cutting all of the defendant's rears and monthly payments in half. 1 week later, defendant had 3 PFA violations. Plaintiff brought charges against defendant on January 14th of simple assault, harassment, terroristic threats with intent to terrorize another. These charges were unfounded and dismissed. Once again, defendant had another 3 PFA violations in a 1 week period and explained to the courts, "I was present at the house because we started working on our relationship and we're living together." Defendant was encouraged to plead guilty to all 3 violations and get less time. Defendant spent 120 days in jail. This came months after defendant dropped a contempt of court on plaintiff when she had me arrested for calling her to exercise my custodial rights. Plaintiff has used PFA laws as a personal weapon to control and victimize defendant in 2015 up until 2019. Defendant spent years learning the legal system in order to defend against false claims. It's important to note when I was incarcerated in 2016, the Wilkes-Barre Citizen's Voice published a front page article about Luzerne County ranking 3rd in the state for granting PFA. Months later, they did another audit from the previous year and found that Luzerne County ranked 5th in the state for granting PFAs. In 2023, they did a third audit showing that Luzerne County has the 2nd highest in the state for granting PFAs. Keep in mind, Judge Tara Toohill presides over PFA cases, and she took the bench in 2022. When she took the bench, we came in 2nd place out of 67 counties in Pennsylvania for granting PFAs. Luzerne County, Pennsylvania has a history of people using the PFA laws for their own personal gain and as a weapon. In the family court, it's well known that this is used to win custody, but it's not only used in family court. Some people will use PFA laws as a form of control, manipulation, or to simply remove someone from their house. This is not what these laws are intended for. This is a smack in the face to the real victims of domestic violence. Defendant challenged the constitutionality of PFA laws in the Superior Court of Pennsylvania in 2019 following another PFA case immediately after the 2015 PFA order expired. On March 26, 2019, after a conciliation conference before Sharon R. Bitzel, conference officer, defendant requested text-only communication as a defense mechanism to prevent false allegations.